In this lecture, we're going to talk about Ninth Amendment right to privacy. If we read the Ninth Amendment, it says, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people." This wording is important for a couple of reasons. First off, does it say anywhere here that we have an explicit, we have an enumerated, a written out right to privacy? No, we don't. The right to privacy is said to be inferred from both the 9th and the 14th Amendment. But we do not have a specific right to privacy in the 9th Amendment. What else this says, why this is important. The enumeration in the Constitution of certain rights. Okay, this is what this is saying is that at the time the Constitution is written, these are the rights that we, the people, we, the government, are aware of. However, if at any time more rights are discovered, then those rights shall belong to the people. They shall not be construed to deny or disparage others retained by the people. So even after creating the Constitution, creating the Bill of Rights, the framers realized there were additional rights out there and that these rights belonged to the people. If we're looking at Ninth Amendment, this so-called right to privacy, remember, it is not explicit. It does not say we have a right to privacy. It is inferred. But we can apply this right to privacy to a number of different areas. The first area we're going to apply this to is reproductive rights. There's 4 cases we're going to go through. The first, Griswold versus Connecticut. In Griswold versus Connecticut, this involves a Connecticut law that prohibited the use of any drug, medicinal article, or instrument for the purpose of preventing contraception. So, no birth control. Although the law was passed in 1879, the statute was almost never enforced. Well, Estelle Griswold, the executive director of the Planned Parenthood League of Connecticut, and Dr. C. Lee Buxton, who was a physician and a professor at the Yale School of Medicine, they opened a birth control clinic in New Haven, Connecticut. They wanted to test this contraception law. The birth control clinic opens, they start handing out birth control, and shortly after it's opened, Ms. Griswold, Dr. Buxton are both arrested, tried, found guilty, and fined $100 each. The conviction was upheld by the Appellate Division of the Circuit Court and by the Connecticut Supreme Court. Ms. Griswold then appeals her conviction to the Supreme Court of the United States. Griswold argued that the Connecticut statute against use of contraceptives was contrary to the 14th Amendment, which states, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person the equal protection under the law." What did the Supreme Court decide? Was this reproductive law by Connecticut a constitutional law or not? 7-2 decision. The Supreme Court ruled against the state of Connecticut. They said that outlawing birth control is unconstitutional. Next case, Roe versus Wade, 1973. Roe versus Wade is a landmark decision by the United States Supreme Court dealing with abortion. It was decided simultaneously with a companion case, Doe versus Bolton. The court ruled 7-2 that there's a right to privacy that the right to privacy under the Due Process Clause of the 14th Amendment extended to a woman's decision to have abortion. So it says, yes, there is a right to privacy under this inferred 9th Amendment and the 14th Amendment. A woman does have a right to an abortion. However, it is not an absolute right. That right must be balanced against the state's two legitimate interests in regulating abortions. These two legitimate interests are protecting prenatal life and protecting women's health. Arguing that these state interests become stronger over the course of a pregnancy, the court resolved this balancing test by tying state regulation of abortion to the trimester of pregnancy. So the court's saying that the federal government cannot outlaw abortion outright. It is constitutional, but the government does have a protracted interest. And as the pregnancy progresses, as the fetus develops more and more, the government's interest grows. Webster versus Reproductive Health Services, 1989. This case is out of Missouri. The state legislature of Missouri passes a law. It imposes restrictions on the use of state funds, facilities, and employees in performing, assisting with, or even counseling on abortions. So what this says is that if some clinic is doing any of these three, facilities or employees are performing, assisting, or counseling on abortions, they are no longer eligible to receive state funds. Well, the issue here is, and what they're saying is that, wait a second, according to Roe v. Wade, abortion is legal. So you're trying to withhold funds, you're trying to punish us for counseling on a legal medical procedure. You can't do that. You can't withhold funds because you don't like it. What did the court say? 5-4 decision. The court says, oh, no, they can. The Supreme Court in Webster allowed for states to legislate in an area that had previously been thought to be forbidden under Roe versus Wade. So the Supreme Court says, yeah, you can start to put some reasonable restrictions on abortion. Gonzalez versus Carhart, Gonzalez versus Planned Parenthood. This case starts in 2003. The United States Congress passes the Partial Birth Abortion Ban Act. What this was aimed at doing is preventing late-term abortions. Of course, the government is sued. The argument is that abortions are legal under Roe versus Wade. You are preventing them with this act from being performed. In a 5-4 decision, the Supreme Court upheld the Partial Birth Abortion Ban Act. It did discuss, or it does prohibit late-term abortions. So this means that we see that the state governments can now put a time frame on when abortions can be performed. Sodomy laws. Take a second out. If you don't know what sodomy is, pause this video, open up another window, look up the definition of sodomy. I'll wait. Have you looked? See, I won't tell you what it is, but once you know what it is, we can talk about this in terms of Supreme Court decisions and Ninth Amendment right to privacy. So, sodomy is simply oral or anal sex. Oral or anal sexual intercourse. So let's talk about Ninth Amendment right to privacy and sodomy laws. First case is Bowers versus Hardwick. This is out of Georgia. Hardwick was the State Attorney General for Georgia. Mr. Bowers has a warrant out for his arrest. An officer is serving the warrant. Somebody lets him into Mr. Bowers' apartment. Well, from there he proceeds to go into Mr. Bowers' bedroom, where he sees Mr. Bowers and another male engaged in a consensual homosexual sexual act. So he comes in and sees Mr. Bauer and his boyfriend engaged in a sexual act. Well, Georgia has a sodomy law. It says that homosexuals cannot perform these acts. Mr. Bowers is arrested, convicted of this charge. His conviction is upheld at the appellate court. So he takes this to the Supreme Court, and his argument here is twofold. Ninth Amendment right to privacy. The government has no business stating what is going on in a bedroom between two consenting adults, but also 14th Amendment. 14th Amendment, that equal protection clause. Remember that was, if it was legal for one, it's supposed to be legal for all. So for the sodomy laws, they only apply to homosexuals. A heterosexual couple can do that. He claims that this is a violation of this portion of the 14th Amendment. What did the court say? 5-4 decision. The court decides there is no right to privacy in your bedroom. The Georgia state sodomy law stands. They say it is constitutional. We're going to revisit this idea in a case called Lawrence v. Texas, 2003. Texas has the same type of sodomy law. Well, Mr. Lawrence has a neighbor who does not like homosexuals. He sees Mr. Lawrence and his boyfriend go into Mr. Lawrence's apartment. So he calls the police, and he actually files a false report. Says there's a crazy man, with a gun or domestic violence, there's something going on in this apartment. You need to get here. So based on this phone call, based on this tip, the police come over to Mr. Lawrence's apartment, break down the door, and they find Mr. Lawrence and his boyfriend engaged in a homosexual activity. Mr. Lawrence is arrested and convicted of violating the state sodomy law. Well, he appeals. Case goes to the Supreme Court. This time, in a 6-3 decision, the court decides that the right to privacy is upheld. We do have a right to privacy between two consenting adults in a bedroom. So they ruled that the Texas state sodomy law was unconstitutional, and Mr. Lawrence's conviction was overturned. Last section for Ninth Amendment, right to privacy. Right to die. Cruzan versus the director, the Missouri Department of Health. On January 11th, 1983, Nancy Cruzan lost control of her old car. And I mentioned it's an old car. This means it had no seat belts, no restraints. She was thrown from it and landed face down in a water-filled ditch. Paramedics found her with no vital signs, but they did manage to resuscitate her, take her to the hospital. After a couple of weeks of remaining dormant within a coma, she was diagnosed as being in a persistent vegetative state. She is brain dead. She is persistent vegetative state, PVS, brain dead. Surgeons inserted a feeding tube for her long-term care. Her husband and parents waited for a more substantial recovery, but eventually, after 4 years, they accepted there was no hope. They decide that they state, hey, Nancy would not want to live this way. She wouldn't want to be kept alive by artificial means. Let's let her pass on. Let's withhold medical care. The Missouri Department of Health is a little worried here. They have a policy that the state of Missouri has this policy that they had the right to require, and this is in quotations, clear and convincing evidence in order for the Cruzans to remove their daughter from life support. The Missouri Department of Health says we have to have clear and convincing evidence from the person who is going to pass on that the person that is on life support actually would want to be taken off. So in this question, does Missouri have the right to refuse the Cruzan family their request to withhold treatment to let Miss Cruzan die? In a 5-4 decision, the court actually found in favor of the Missouri Department of Health. So they said, no, Missouri, you don't have to pull the plug. But they did say that an individual, we have a right to withhold treatment, but it has to be the clear will of the person. We cannot be ambivalent. We cannot be ambiguous about it. We have to flat out state that we would not want to be kept alive by artificial means. We could do this in a couple of ways. We could do a living will, stating that if anything ever happens to us medically, we don't want to be brought back. We can leave a do not resuscitate order, anything like that. Assisted suicide cases. Do we have the right to have somebody end our life? If somebody helps us end our life, does that protect them? Are they protected legally? This goes back to the 90s, maybe even the late 80s. There is a doctor named Dr. Jack Kevorkian, medical doctor. What he would do if people were sick, they were terminally ill. Terminally ill means they're not going to get better. They're going to pass on. These people who were terminally ill would contact Dr. Kevorkian. They would ask for his assistance. He would request their medical records. These people send him their medical records. He reviews it. If he agreed with the diagnosis, if he said, yes, you are terminally ill, you are not going to get better, I will help you move on. He had created this little machine that would assist in you committing suicide. So he'd come out to your house and he'd set up this machine, put an IV into your arm. He'd put this drug cocktail, this drug combination to his machine. He said, okay, I'm going to leave. When you are ready, push the plunger. It'll release the drugs into your system, killing you. I will be back in 4 hours. I will clean up the body. I will clean up my equipment, and I will call the police. I will call the proper authorities. So he would leave, and when the person was ready, they would go ahead and push the plunger and commit suicide. Well, he was eventually arrested and charged with murder. And his defense is, look, these people have a Ninth Amendment right to privacy, and they are exercising it, and actually, you can't even charge me for murder because I am giving them the means, but I am not the one who is actually doing it. I am not the ones injecting these drugs into their body to kill them. Did this work? Does the court believe we have a right to assisted suicide? 9-0 decision. The court says, nope, sorry, there is no constitutional basis for assisted suicide. Terry Schiavo, 2005, out of Florida. This was just a mess to begin with. Mr. Schiavo comes home, finds his wife Terry on the floor. She suffered a stroke. Calls the ambulance. They stabilize her. They get her to the hospital. Hospital says, I got good news. I got bad news. She's going to live, but she's going to remain in a persistent vegetative state. She's going to be in a coma the rest of her life. She is brain dead. Mr. Schiavo says she wouldn't want to live like this. Let's withhold treatment. Her parents say, hold on. We believe that through faith and through prayer, she will get better. Please do not pull the plug on her. Mr. Schiavo says, I'm glad you feel that way. I'm glad that your religion comforts you. Withhold treatment. Mrs. Schiavo's parents say, hold on. Tell you what. Transfer her care over to us. Make us her legal guardian. You will have no responsibility. We will take over everything, bills, all the decision making, everything. You can walk away. Mr. Schiavo says, well, that's a mighty generous offer, but she wouldn't want to live like this. Remove her from life support. At this point, who has the right to make this decision? The husband or the parents? I mean, think about it. This is actually an iffy thing. Who has the right? The husband or the parents? So, we have Mr. Schiavo. We have the husband arguing with her parents over who has the right. Initially, the lower court says Mr. Schiavo has the right to make this decision. The feeding tube is removed. A few days later, another court orders it are placed back in, thanks to a lawsuit by the parents. And this was just a horrible situation. The courts are going back and forth, and who has the right to make this decision, the husband or the parents? The national government gets involved. We see our legislators, and we even see our president say this is who should have the right. But ultimately, the lawsuits come up to the Supreme Court. So, who does the Supreme Court believe should have the right? Who do they say should have the right to make that decision? The husband or the parents? The Supreme Court, in their infinite wisdom, said, no, we're not going to get involved in this. We're denying certiorari. We are not even touching this case. So, they said, nope, thank you. They're not involved.